Good evening and welcome to this short video clip on mens rea. The definition of mens rea is simply the guilty mind. This means that most of the time there has to be a combination of actus reus and mens rea. Actus reus, you remember, means the wrongful act or the external elements of an offence, and the mens rea means wanting to commit the actus reus or the guilty mind. Another point that you must remember is that there are four types of mens rea. The first type is intention, which is divided into direct intention and indirect intention or oblique intention. The second type of mens rea is referred to as recklessness. And there are two types of recklessness, or there used to be two types: objective recklessness, which we just need to know for historical purposes, and subjective recklessness. So the point you need to remember is that there's really only one type of recklessness now, which is subjective recklessness. The third example of mens rea is knowledge, and the final example is negligence. And we'll talk about those different types in another video. Now, the courts have always struggled to define what indirect or oblique intention means. So to give you the definition, oblique intention is where the defendant wants to achieve one aim, but they are aware that in order to achieve that one aim, they must also achieve a second aim, which they probably do not want. An example would be where the defendant wants to throw a stone to hit the victim who is standing behind a glass window. Now, they have direct intention in relation to throwing the stone to hit the victim behind the glass window. But in order to achieve throwing the stone and hitting the victim behind the glass window, they must shatter that glass window, which is an offence in itself, criminal damage. So do they have intention or will they be guilty for smashing the glass window? Well, the court would say in relation to the glass window, the defendant had indirect or oblique intention simply because it must have crossed their mind that in order to achieve the first aim, throwing the stone at the victim, that they must shatter the window, and therefore they have intention to shatter that window. We'll have a look at other examples in a minute. Now, the first example that you may want to consider in terms of explaining what intention is or indirect intention is Section 8 of the Criminal Justice Act of 1967, where the court said simply just because the defendant realizes that their actions will bring about a bad result does not necessarily mean that they have intention. So that's Section 8 of the Criminal Justice Act of 1967, which confirms that knowing that your actions will bring about a bad result doesn't necessarily mean that you have intention. The case of Maloney confirms that foresight of consequences does not necessarily mean that you have intention. It's only evidence of intention. And then the case of Hancock and Shankland. And these two cases, Maloney and Hancock and Shankland, you would have prepared some brief case facts on those cases. But in Hancock and Shankland, the court agreed that the higher the probability of a bad consequence, the more it is likely that the defendant wanted to bring about that bad consequence. Another case to help us out with the definition of indirect or oblique intention is the case of Nedrick, where the courts agreed that if the defendant realizes that their actions are virtually certain to bring about a bad result, then the jury may infer that they had intention. And then finally, the case of Woolen confirms that where the defendant realizes that their actions are likely to bring about a bad result, then the jury may find intention. Let's move on very quickly to recklessness. And for historical purposes, objective recklessness under Caldwell is where the defendant's behavior doesn't match up to that of a reasonable person. And if you think about it, the objective standard or objective recklessness was a very high standard, which meant that most criminals were found guilty of offences. Because if you commit a crime in the first place, then your behavior really doesn't match that of a reasonable person, because a reasonable person wouldn't commit an offence in the first place. The current type of recklessness is subjective recklessness, as defined initially by Cunningham in 1957, but is now confirmed in the case of RNG in 2003. And this relates to subjective recklessness. So if the defendant didn't realise that their actions would bring about a bad result, then they couldn't have intended that particular result. So that, in a nutshell, is a very quick summary of mens rea. No doubt we'll go into a lot more detail when we have our lessons online during the week. Thank you for watching this video, and I shall see you all in lesson tomorrow.